And since today is Constitution Day, we'll be covering our founding document and why it is so critical to our existence as a free people. And here to help us do that is Amy Swearer, a legal fellow in our Meese Center for Legal and Judicial Studies and host of our SCOTUS 101 podcast. Hi, Amy. Thank you for joining us.
Hi, thank you for having me.
All right, so everyone watching, please type your questions for Amy in the comments below. And heads up that if you want to know anything about the Second Amendment, Amy is the best person to ask. All right, so to get us started, Amy, could you give us just a quick overview about our Constitution? Why is it important?
Sure. So I think the first question, sort of the broadest question, is what is the Constitution? And it's good to think about it sort of as like a compact or a contract by which all of these individual states agreed to come together as one nation. And it sort of sets the rules, sets the terms and conditions for how these states are going to act and sort of the powers and how they're going to share those powers. And it really sets the rules of the game for our system of government, almost like a founding charter of a corporation or anything like that. It sets the rules, it sets the boundaries, and I think importantly, it's something that all of the states ratified. All the people of these states agreed to it. So it wasn't imposed on the states. It's something they came together and created and then agreed to and ratified this document.
And what makes it special or different from other founding documents of other countries?
So I think there are a couple of things that we can point to, and it's namely sort of the system that was set up. So the first thing that is important is this understanding of a government, a federal government of limited enumerated powers. So it's not this document that says the government can do whatever and here are the rights you have. It's a document that says here are the few limited things that the federal government can do, and anything else is outside of the boundaries. So it sets up what the government can do, not what you can or can't do. And then it also incorporates what we now call the separation of powers. So it's this idea that too much power in the hands of one body or one person or one system doesn't have a real good check on it, that it's dangerous. And so we've actually set up three different branches of government. You have the executive branch, the judicial branch, and the legislative branch. And those three branches each have specific limited powers, but they all also offer a check and a balance to each other. That is, they kind of keep tabs on each other, and it's sort of this way of dispersing power and balancing it out so that no one branch or entity can sort of take over. And then on top of that, the final thing that's important to understand is this idea of a system of federalism. So not only do we have checks and balances horizontally with the three branches of government, but we have checks and balances vertically, because again, remember, we set up a system of limited federal government that it only has those express powers that were expressly granted to it. So then we have a diffusion of power vertically, where all the other powers, this broad base of power that we call the police power, basically everything else is left to the individual states, to the government that is closer to the people, and that can react not on a national level, but on a more local scope according to the needs of the people. So again, we have a horizontal and a vertical diffusion of power that all kind of checks on each other to balance that out and really sort of check against tyrannical control.
Thank you for that explanation. Definitely important for all of us to understand. And so for those of you watching, if you go to heritage.org/Constitution, we actually have the Heritage Guide to the Constitution, which lists everything out for you. So if you're interested at all, go check that out. We will link it in the comments as well. Also of note, we have a Preserve the Constitution series coming up, events that you can watch that talk about all these important topics. And another note, we have a great new article from our Heritage President, K.C. James, a new article, Never Before Have We Had to Defend the Constitution Like We Have Today. So important. We're also going to link that in the comments below. So check all of that out when you get the chance. And please comment below with any questions you have for Amy as you're watching. Amy, just to keep going here, an article that also gets a lot of traffic on heritage.org is what the Constitution really says about race and slavery. And there is also in our event series an event called Slavery in the Constitution that will address this as well. But could you touch on what the Constitution says about slavery? Just was our founding document protective, antagonistic, or neutral towards slavery?
Sure. So I think the proper way to view this subject of slavery in relation to the Constitution is this idea of, again, the Constitution was a compact, and slavery was it is a thing in a subject that is recognized and acknowledged by the Constitution. But I think, if anything, it's actually antagonistic. So we had a situation in which the framers of this Constitution had a choice. There were several states and people for whom slavery was important. And in order to get agreement on this really historic document, this idea of a government by the people, for the people, of the people, there needed to be some compromise that essentially to acknowledge slavery was a necessary condition of getting the proper conditions to set up this Constitution. But that in the end, when you actually look through the Constitution, it's quite antagonistic of slavery and actually sort of sets the stage for it to be gotten rid of in the future. That it sort of acknowledges this is not consistent with some of the other very important factors and theories on which the Constitution is based. And there are two things in particular that I'd point to with this. I think the first is how the Constitution treats the slave trade itself. So one of the compromises was that, Congress in the Constitution was given, I think, a period of 20 years in which they said, okay, you can't legislate against the slave trade. But then after that, it's fair game. And actually what happened then, as soon as that condition expired, Congress legislated and ended the slave trade, that it was sort of set up to allow that in the future. And then the second thing that I think has been traditionally misunderstood, especially lately, is the 3/5 compromise. This idea of how are we going to count slaves for purposes of representation, both in the Electoral College and for setting the House of Representatives. And what you had were slave states, heavy slave states, who wanted to exacerbate those conditions and to say, look, we have all of these people who can't vote, who aren't citizens, but we're going to count them for representation. And it would have given a tremendous amount of power to those slave states to essentially solidify that condition. The 3/5 compromise was actually a method of taking away some of that power they desired by reducing their ability to count slaves who couldn't vote, who weren't considered citizens, who were treated horrifically, in order to sort of solidify that power. So it actually was a counterbalance against what many of the slave states wanted, and actually, again, was one of the conditions that allowed for things like the Electoral College, the election of Abraham Lincoln, and sort of this balance of power in Congress and in our federal system that eventually led to the abolition of slavery itself.
And for those interested, like I mentioned, there is a virtual event on September 29th called Slavery in the Constitution. So check that out if you are interested in that topic. Shifting a little bit, like you mentioned, misunderstandings right now. We've seen some unconstitutional issues arising with just crazy current events and all the things that are happening. You have a recent article out about the CDC's unconstitutional moratorium on evictions. Could you tell us why is the CDC's order setting a dangerous precedent?
Sure. So the CDC, for those of you who don't know, it's the Centers for Disease Control and I'm blanking up. But it's a health organization under the executive branch. So this is not a legislative agency like Congress. So when you look at the powers that the executive branch has under the Constitution, it only gets to set sort of policy, legislative parameters under limited specified conditions when Congress says, hey, we're going to give you some room to work with here to set some health policy, you guys, the experts over at the CDC. They don't have the power to just legislate outside of that in whatever context they want. And so the CDC, if you recall, Congress earlier in the summer through the CARES Act passed a moratorium on housing evictions for certain conditions, so that people who couldn't pay their rent, if they were part of a federally subsidized housing complex, they couldn't be evicted. The CDC, after that congressional order expired, said, okay, well, we're going to step in, and Congress isn't going to legislate, so we're going to legislate. And they took a very limited amount of authority that they had to do things like fumigate apartments, or step in a limited circumstances when states weren't able to take care of checking the spread of diseases themselves. And they said, oh, we're going to take that and we're going to stretch it, not just to the limits, but beyond any reasonable limit whatsoever. And they imposed this sweeping order barring evictions from any landlord, any residential evictions from any landlord for the duration of the order, so essentially to the end of the year. So if you have someone who can't pay their rent, not only can you not evict them, technically you can't even start the process against them. And it's very problematic, not just for policy reasons, but because, again, from a constitutional perspective, the CDC is not the branch that is accountable to the people. You can't elect or unelect or remove CDC officials for this like you can with Congress. And so it sort of opens the door for these unaccountable executive agencies, if they're allowed to interpret statutes in this way to give them sweeping power, we really don't have a check on the executive branch anymore.
Very interesting. And another topic of conversation right now is obviously policing, that is in the news all the time. You have a recent article, another one, a great one, about Jacob Blake and the conversation and what we need to see in policing reform. Could you tell us just a little bit about that, touch on that article and what's preventing meaningful police reform right now?
Sure. So I think this has less to do with sort of the concept of the Constitution and our rights under it, but I think it is a very important topic that is part of a national conversation right now. And so, look, I'm someone who very much wants to live in a society where police are held accountable for unreasonable actions, where they're well trained to avoid unreasonable escalation. But I think it's important, and I go with this in the article, with this theme in the article, to understand that when you're dealing with police-civilian interactions, there are by nature two aspects of that interaction. There's both what the police officer does, and then there's also what the civilian does. And just like the third law of thermodynamics, right? For every action, there's an equal and opposite reaction. Newton, of course, is talking about thermodynamics, but I think it holds true for sort of interactional relationships too, and those sorts of interactions where your actions as a civilian really do have a reasonable effect on how law enforcement officers then react. So you're dealing with a situation of Jacob Blake, who was an irate person with a felony warrant out for his arrest, who was being lawfully arrested, who showed up, broke a restraining order, physically fought with cops, clearly did not want to go to jail that day, brushed off a taser. And that's sort of the context then in which we get to him storming toward his car and being shot by the officer. Now, again, I don't know that there's enough evidence to completely say that officer did nothing wrong. He was completely justified. It was completely reasonable. But I think an important part of that conversation is not just what the officer saw, but how Jacob Blake's actions helped facilitate and exacerbate that situation to put that officer on edge. Because I think the unfortunate reality is that when you go through a lot of readily available videos, and I link to a lot of these videos in the article, that sort of situation where you have an irate person who clearly doesn't want to go to jail that day, who seems willing and desperate to do whatever they can to avoid jail, you get a lot of situations where mere non-compliance turns into very quickly that suspect pulling a knife, pulling a gun, shooting, wounding, killing officers. And I think it's important to understand how the officers are seeing that and why they might be reacting in a certain way.
And sort of on that topic, we have an audience question here about riots. So does the federal government have jurisdiction to arrest rioters? And if so, under what circumstances?
So this is a very good question. And the basic answer is the ability to arrest people for more state and local crimes, your basic sort of criminal activity, that generally rests with the state. Because again, we talked about earlier on, it's the state government, not the federal government, that has the general policing power. That's why a lot of murder convictions, a lot of assault convictions, those are all under state law, not federal law. But I think it's important to realize, too, that there are some scenarios in which the federal government does have jurisdiction. And so I think we saw this in Portland, where we were dealing with federal property. It was a federal courthouse. So that's why in federal courthouses, you will see federal marshals, federal officers. So they generally have jurisdiction to protect their federal property. There are also certain types of instances that affect interstate travel. So there is a federal statute. It's rarely used, but there are conditions where, like, if you're blocking traffic with the intent to block interstate commerce, and you're also doing it under some other conditions, that can be a federal crime for which you can be arrested. And then also there is this idea of how governors can ask for federal support to pull in the National Guard for that sort of thing, for policing support, except they're not really police in that situation. They're more like crowd control, riot control. And then the final aspect, and again, I think you've seen this a couple of times with federal agents coming in, are for things that are federal crimes. So if they are suspected of or charged with terrorist activities, that falls under federal jurisdiction. But again, there's kind of a high bar there. Not everyone who riots or loots or burns stuff down is a terrorist or part of a terrorist organization. And so it gets kind of into this gray area there about who's a terrorist and who's just a rioter. But so there are situations, limited situations, in which the federal government may have, some leeway there. But as a general rule, it is the state government who is responsible and has the authority, the constitutional authority, to deal with things like local riots.
Great. And I want to shift the topic now to the Second Amendment, because you focus on it a lot. But before we get into the Second Amendment, could you give us sort of a quick history lesson about the amendments and why they're added?
All of the amendments, or just the second?
All of the amendments. We have a question here concerning adding of amendments. So just a quick overview about the amendment.
Yeah. So two things. So we have the first 10 amendments, which are known as the Bill of Rights, which were ratified very quickly after the Constitution itself was ratified. And the general idea there was that even though, again, the Constitution is set up to be a limit on the federal government by telling it, look, these are the only powers you have, you can't do anything else. But there were certain other types of rights that were so fundamentally important that a lot of people at the time felt it was important to have sort of a list of these rights to say, look, not only does the federal government only have these limited powers, but whatever they think they can do with those powers, these are the certain aspects of citizens' rights that you can't touch. So, for example, the right of free speech. Congress shall make no law about that, regardless of how it impacts taxing or interstate commerce or anything like that. The Second Amendment, that the people shall not have their right to keep and bear arms infringed. It's important to keep in mind that prior to the 14th Amendment, these were just limits on federal power. But then after the Civil War, what happened was you had a lot of states who basically refused to protect the newly freed men, the former Black slaves, in any capacity under their state constitutions. Taking away any rights they may have had, even if they were rights that you just consider people normally have as citizens of the United States. So we passed the 14th Amendment, which basically then bars state governments. And it now applies to the state governments as well, that regardless of what their state laws or constitutions say, they can't violate your right to free speech. They can't violate your right to keep and bear arms and that sort of thing. And one final point that I'll make with that is, we hear a lot about this argument that, do we have a living constitution or not a living constitution? And what that often means when people say, oh, we have a living constitution, is that they think that the meaning of the Constitution and its protections should change without changing the document itself. So that it's 200 years later, it no longer applies. So we're just going to sort of change what it means. But that's, again, not the way that the Constitution is set up. So the Constitution is a living document in the sense that we can amend it, we can change it. But just like we set up the other rules of the game, one of the rules that we set up and agreed to was the process of how to change it. We set a really high bar to make sure that if we're going to change the Constitution, there's going to be widespread agreement amongst the various states. And so it is a living Constitution in the sense that we have a process to change it. We have changed it 27 times. But it's not a living Constitution in the sense that, outside of those rules of how we change and amend it, we can just say, oh, well, it means something else now because it's no longer relevant.
So we have a question here. Should there be an amendment concerning the regulation of the internet, electronic data, and possible online voting?
So this is not my area of expertise. As a general rule, so there were a lot of factors that were in that one proposed amendment. But as a general rule, as it stands now, at least, the First Amendment is important for the free exchange of ideas, for not regulating those sorts of things, and it's sort of this balance that we struck. That in so doing, you have people who will say and do horrible things, especially on the internet, and it's the same thing with the Second Amendment. All of these rights. In protecting those rights for law-abiding citizens, it opens the door for people to harm others. The Second Amendment, yes, it protects my right to keep and bear arms, but it also makes it a little bit harder for governments to do things that other countries have done to protect against criminal gun violence. That's sort of the balance that we've struck. And I think at least, I don't know my particular thoughts on those proposed amendments, but I will say this, the person who asked that question is at least on the right track, that the way we go about handling things, like if we want laws that would clearly violate established rights, the way to do that isn't to say, well, we no longer think the First Amendment means what it meant, all those times when we agreed to it. It's to say, we're going to amend the document itself, and we're all going to agree to these new rules of the game.
All right, so your area of expertise is the Second Amendment for sure. So could you have a monthly roundup of examples of defensive gun use, and lots of great articles on heritage.org and the Daily Signal. We can link some of those here. You have a database on heritage.org about that. Why is it important to tell these stories?
Yeah, so, just from the standpoint of the stories in the database, we talked about the national conversation about policing and police reform earlier, and about how, there's two sides to it. It's not a one-sided conversation. And so often what happens when we start talking about gun regulations and gun violence and gun deaths, it becomes this one-sided conversation where all we talk about are the rare events of mass shootings or criminal gun violence, but we don't talk about the reason the right exists. We so often don't talk about the people whose lives and livelihoods are being defended and protected because of their ability to stand there and defend their own inalienable rights with a firearm. And so that was sort of what we wanted to do here, was add in that other side of the conversation. So often people don't really even see the stories when they do come up in the news. If you missed the 30-second snippet on your local nightly news, you may not ever see it. You may not know that in your city, your neighbors, your neighborhood, there are people who are defending themselves and who are utilizing their Second Amendment rights in very, very vital ways. So we just thought it was important to tell that other side.
Absolutely. And for those of you watching, please chime in with any questions you might have about the Second Amendment. Amy can pretty much answer anything on that. She's got a lot of great content out there that we will link in the comments. Just to touch on some of the misconceptions about the Second Amendment, why do we need an armed citizenry? Why is that important? Why do we need this?
So let's go back to a bit of a history lesson here. So the right to keep and bear arms is not something that was created. It's not something that the founders sat around and said, it'd be really cool if we had this. This was a right that they believed themselves to already have as British subjects, that this was something that they had, already acquired. And the theory behind this is, especially when you have a system of representative government, where it's a government of the people, by the people, for the people, that the most natural defense of that, the most natural defense against tyrannical government is actually an armed citizenry. It's this idea of, he who has the arms has the power, and that if we are a government of the people themselves should be the ones who have arms. And then it also rests again on this idea of self-defense, that this natural and alienable right to self-defense, that the most rational way of enforcing those rights and defending and protecting those rights, whether it's self-defense collectively against a tyrannical government, whether it's self-defense collectively against an invading army, whether it's individual self-defense, community coming together to suppress riots, which for the longest time was how we did policing. We didn't have professional police forces. We had sort of community policing, or whether it's you against a lone criminal, that you, as a citizen, not a subject, have the right and the rational response of protecting and defending yourself. That again, the power belongs to the people. Then it belongs to you to have that counterbalance, that armed population. And so it's sort of this philosophical concept, again, just like we talked about, how we have different branches of governments with checks and balances on each other, that an armed populace serves as a check and a balance to remind the government, look, you don't have unlimited control over us. We do have, sort of this safety valve, if you will, this last resort of protecting and defending ourselves. Because when you look historically, just throughout history, the rise of tyrants and tyrannical governments, the first thing they do always is disarm the people. So it's not, it's not a sufficient condition. It's not as though I think if all of our guns were to disappear from civilian hands tomorrow, that all of a sudden we'd have this massive tyrannical government with people thrown into concentration camps. But it is a necessary condition that when you remove that last final balancing of power, there's really nothing except a piece of paper and your hopes that the government won't become tyrannical.
All right, and going back to the Constitution a little bit, we have a question here about adding new states. We have a question that says, what are the constitutional provisions that would allow the people in Eastern California to establish a new state? Are there any at all? Could you help with this question?
So, I mean, this has happened in the past. West Virginia was initially just Virginia. So you do have states that break off. Generally speaking, you cannot have part of a state break off to become a new state without the rest of that state agreeing to it. So East Texas couldn't go, oh, we want to be East Texas, while West Texas is sitting there, no, we don't want that. So there needs to be an agreement. You could have part of California break off. You could have a voter referendum where Californians say, hey, we'd be better served as 7 different states. And then each of those 7 different states could basically, it's an application process to the federal government to become the next state. So it has happened. There is a process for it. I don't know how likely it is to happen at any point in the future, because again, it takes agreement from a lot of parties. You don't just have the right or the ability to unilaterally say, oh, we're a new state now. But it's there and it can happen. It's a good question.
Thank you for the explanation. We have time for a few more questions for those of you watching. So type anything in the comments and we will try to get to those questions. One question here about policing. What is the difference of a community policing itself and vigilantes? Can you explain that?
Yeah, so it is a good question. And so first of all, let's define what we mean by vigilantism. So vigilantism is this idea of, at least as I understand it, affirmatively going out and taking the law into your own hands, refusing to abide by the normal process that we have for it. And I think that's different from self-defense, which is this idea, and an idea we highlight quite frequently in our defensive gun use database of, look, when criminals find you, and you're not going out looking for them, but they find you and try to violate your rights while you're just doing your thing, you have a right to defend yourself. And actually in every state, you also have a right to detain that person and turn them over to law enforcement. So when you look at sort of the history of policing, this idea of citizens arrest in particular comes from the old hue and cry. We didn't have a professional police force. We had citizens who actually had a duty when the hue and cry was raised to go and find and track down this criminal, sort of like, every man's an officer. But there were still, again, rules with that. You had to use reasonable force to bring him in unless he was a felon or was dangerous. And then he went through the trial process. So, I know sometimes when it gets into this idea of riots and sort of protecting communities, it's this idea of you want to, as much as you can, go through the normal democratic due process, due process, all of these, jury of one's peers, that you're not just going out and saying, hey, you're a criminal, I'm going to shoot you. That there is again, we've talked about this a lot, that there's an agreed to set of rules and norms. And that's really what you saw prior to like the rise of policing. There was this sort of agreed to set of rules and norms under the common law about even as you as a person arresting someone, there were duties and things that you had to abide by in terms of, what you had to do, the rights you had to abide by. Again, it's a little different now because we do have the norm of professional policing. And so that's why I'd say my guess is, and maybe I'm reading this into the question, but if we're talking about in terms of like riots and community defense, that there is an agreed to system within your community. It's not just like you going around saying, I'm going to protect this person's property, but you have some sort of collective consensus that is also working within the confines of the criminal justice system in your state, that you're not going out and saying, we're going to detain you and try you and convict you outside of the norms of what we've set up in our state. So again, I know there's sort of some gray areas there, and I think it's important as gun owners, particularly gun owners in times of chaos and rioting, to be very aware of what those gray areas are. And the last thing you want to be doing is to charge headlong into those gray areas, because one, morally, I think it's questionable, and two, from a legal standpoint, that's where you start getting into trouble. So as much as possible, and this would actually be a word of advice: know the laws of your state, know the criminal justice system of your state, and understand and try to figure out how community defense fits into those laws and norms, instead of just going out trying to find criminals and trying to find people to bring to justice. And I think that's sort of a good way of looking at that balance.
Absolutely. And another question here relating to firearms. Might we be able to predict when the ammunition shortage will end? There are many moving parts as to why we're experiencing one now, but how long do you think this might go on?
Yeah. So actually someone posted a meme on my Twitter the other day where so for those of you who don't know what's going on, there have been millions and millions of new gun owners. Gun sales are through the roof. And part of that, part of the opposite side of that is that there's a very severe ammunition shortage. It's actually hard to find ammunition in some states now because it's flying off the shelves the second that it's in. And so it was, this picture of a happy person, or it was like, gun owners learning that millions of Americans are joining their ranks. And then it was like a sad person crying, where it's like gun owners when they realize that this means they're buying all the ammo too. I don't know, I don't work in the firearms industry. I know that a lot of manufacturers are trying to up their production, that they've been at max capacity and they're trying to figure out how to expand. And sometimes it's been hard given conditions and restrictions with coronavirus in some states. So I don't know what the answer to that is. My guess is it will ease gradually, just like we saw we saw that, the insane toilet paper shortage places in America went through. Production caught up with that. It's a little bit harder with the gun industry because they're so heavily regulated. I don't think people have any idea how heavily regulated some of these companies are. I think it will ease, but it's going to continue to be a crunch, I think, especially as long as we keep seeing this drastic uptick in people buying guns for the first time.
Absolutely. For those of you watching, just keep up with Amy. She writes a lot of great content on this. So on heritage.org, you can find a lot of good information, and on the Daily Signal as well. So I think this might be a good question to end with. Okay. What can we do to play a role in defending the Constitution?
Yeah, so the first thing I'd say is educate yourselves. I think one of the biggest hurdles we face as a society is a lack of education, a lack of people who understand what the Constitution actually says and what it means, and two, why it's important. There's just so much misinformation. And so the more that you understand it yourself, the better able you are to combat some of that misinformation and sort of strengthen the national understanding, the national coherency when it comes to the importance of the Constitution. So I'd say that's the first thing is educate yourself and understand how to educate others. I'd say that the second thing is get involved. People put so much stock into the federal government and Senate races and the presidential race, and those things are important. They are absolutely important. But a lot of times, a lot of these restrictive conditions, you look at whether it's coronavirus restrictions, whether it's gun restrictions, honestly, whether it's free speech restrictions, a lot of these, things that you care about, pro-life laws, abortion laws, those things happen at a state and local level. Get involved in what's going on in your state and local government. You see this. I live in Alexandria, down in Virginia, and we had our city government pass a pretty restrictive gun measure, basically saying even if you have a concealed carry permit, you can't carry on city property. The end. Where it's a lot of these restrictions come at a level that you actually can play a very serious role in. But a lot of people don't. They pass up the ability to get involved at that state and local level. Whether it's even school boards. I mean, you want to talk about misinformation and sort of control over, the upcoming generation. Getting involved at those levels. Educate yourself, get involved. I'd say those are two of the biggest things that you can do.
Yeah, totally. And I think this has been a fantastic conversation. Thank you so much for your time, Amy.
Thank you for having me.